A very good morning to all my dear students. Today we are going to discuss about the drafting of lease deed, partnership deed, and mortgage deed under the subject captioned as drafting, pleading, and convincing. My dear students, as you are aware that Unit 4 pertains to convincing. As such, these are the topics which has been mentioned in the university syllabus there. So let's start with the same. As far as the drafting of lease deed is concerned, one must be thorough with the concept of lease. As such, we may refer to certain important essentials and the definitions of the lease. As far as the concept of lease is concerned, it is submitted that a lease is a transfer of an interest in an immovable property, which is the subject of lease. From this, my dear students, we may infer that lease pertains only to immovable property. As such, there cannot be a lease of movable property. Like in the case of sale of movable as well as immovable property. Further, that the interest is the right to occupy and use the property. Thirdly, lease is given for a period and on such terms and conditions as agreed between the parties. Further, the transferor of property is called the lessor, and the person to whom it is transferred is referred to as lessee. Furthermore, as far as the definition of lease is concerned, it is relevant to point out and to refer to the provision of Section 105 of the Transfer of Property Act, which defines the lease as under a lease of immovable property is a transfer of right to enjoy such property made for a certain time, express or implied, or in perpetuity, in consideration of a price paid or promised, or of money, a share of crops, service, or any other thing of value to be rendered periodically or on specified occasions to the transferor by the transferee who accepts the transfer on such terms. So from this, we may infer that following are the parties to the lease. Number one, the parties to the lease are lessor and lessee, and they may be referred to as lessor, may be referred to as landlord, and lessee may be referred to as tenant. Now we will look into the essential ingredients of a lease deed. Number one, parties to the agreement. Like lessor and lessee must be the party to the said deed. Second, the identification of the property or the subject matter of the arrangement or the lease. As far as the subject matter of a lease must be immovable property, which is defined under Section 3 of Transfer of Property Act, which defines the immovable property as the word immovable property denotes the land itself and a physical object and sometimes the estate in the land. Furthermore, the immovable property may be corporeal or incorporeal. Third is the term of lease. And there must be some rent which needs to be paid by the lessee to the lessor. And thereafter, the lease deed must contain the date of the commencement of the lease and the expiry of the lease. As far as the lease how made is concerned, it is submitted that you may refer to the provision of Section 107. Section 107 of the TPA or the Transfer of Property Act 1882 lays down that a lease of immovable property from year to year or for any term exceeding 1 year, reserving a yearly rent, can be made only by registered deed. Next. As far as the term of the lease deed and its termination is concerned, it is submitted that the lease deed of agricultural immovable property shall be deemed to on yearly basis in absence of any contract or law governing the execution of deed. Deed to be terminable on the part of the either the lessor to the lessee by giving 6 months notice, or for any other purposes other than the agricultural purposes, it shall be for a monthly basis, terminable by either lessee or by lessor by giving 15 days notice thereof, meaning thereby, and under the law, both lessor and lessee has the power to terminate the lease deed. The law aforesaid is contained under Section 106 of the Transfer of Property Act. Now, I just want to describe the interplay between the Transfer of Property Act and the Stamp Act 1899 regarding lease deed. Stamp Duty Act 1899 enumerates the value of the stamp duty payable on different lease documents. As you all are aware, lease deed can be as an ordinary agreement under Article 5 of the Indian Stamp Act and corresponding provisions of the Stamp Duty Act. Agreement of lease amounts to a demise. It is required to be stamped under Article 35 of the Indian Stamp Act. Under Article 35, duty charge is on the average annual rent, which is multiplied by the number of years according to the length of the lease period. So, from this we may infer that how this lease deed duty is concerned or the fee applicable is concerned, the same would be referred or same is provided under the relevant provisions of the Indian Stamp Act. So my dear students, this is the interplay between TPA and Stamp Act. Now, Before I would like to dwell upon the drafting of the lease deed. I just want to apprise you the difference between lease and license. A lease is an agreement between a landlord and a tenant. Further, it gives the tenant an exclusive right in a property. A lease requires a written or oral agreement between two parties, whereas license is the permission from the owner to a licensee to do something. A licensee does not always require a written agreement. Now, what are the checklists of the key elements to consider when drafting a lease deed? So, my dear students, please refer to these checklists before drafting a lease deed. And these are property description, meaning thereby you have to describe the property which needs to be transferred under the lease deed from the side of the lessor to the lessee. Further, the lease deed must also contain the duration of the lease. Further, proper title search may also be done by the lessee. There may be a lock-in period in the relevant covenants of the lease deed. There must be a termination clause in the lease deed as such. Further, it contains the rent payment and the security deposit clause in the said lease deed. It may also have the charges, if any, to be charged from the lessee by the lessor. Further, the lease deed may contain the provisions relating to subletting also, meaning thereby whether subletting is allowed or disallowed under the said lease deed between the parties. Further, it must contain the applicable law pertaining to payment of stamp duty and registration of lease deed. It must also contain the legal charges, if any. Further, it may contain the procedure for the handover of possession from the side of the lessor to the lessee. It may also contain the insurance cover as such. Further, it may contain the jurisdiction of the relevant court and the respective indemnities in the case as such. Now, with this or in this background, we may start drafting the lease deed. As you all are aware that when I have dealt with the components of deed, I have mentioned you that in each and every deed, there must be a description of the deed. And a description of the lease deed is concerned is that it may be written as lease deed at the first instance. Further, it must be in capital. So that's why we have written the same in capital as well. This deed of lease made on dash and dash day of this month of this year between Mr. A, son of so and so, resident of so and so, hereinafter referred to as the lessor, which term shall mean and include wherever the context so requires or admits his or their heirs, successor, administrators, executors, attorneys, and assignees of one part, and a bank or a body corporate hereinafter referred to as the lessee, which term shall mean and include wherever the context as admits or requires its successor, administrator, and assignees of the other part represented by its manager and holder of the power of attorney dated so and so, Shri so and so, son of so and so, resident of so and so, witness as follows. Whereas now we have to mention the recital to the lease deed also. Whereas the lessor is or are the owners of the building number so and so, situated at so and so, which is declared to be the value of so and so. Whereas the ground floor, first floor, measuring itna, carpet area so and so in the said building, more fully described in the schedule here too, and hereinafter called the said premises was or were vacant and ready for occupation. And whereas the lessee, being in the need of accommodation for its use and occupation, approached and requested the lessor to grant lease in its favor in respect of the said premises. And whereas both the parties now desired to reduce the terms into writing, and whereas the lessor agreed to grant lease in favor of the lessee in respect of the said premises, it is now hereby agreed as follows. Whereas the lessee is already a tenant under the lessor in respect of the above building, fully described in the schedule hereto and hereinafter called the said premises, paying a monthly rental of rupees so and so, and whereas the lessor approached and requested the lessee to pay an enhanced rental of rupees so and so, and whereas the lessee consented to pay the enhanced rental of rupees so and whereas both the parties now desire to reduce the terms into writing, it is now hereby agreed as follows. This lease is for the purpose of rent, and the rent of the and the period of the lease shall be deemed to be commenced from so and so. This lease shall be in force for a period of so and so years. Certain itna, the lessee shall, however, have the option to continue the lease thereafter for a further period up to so and so. The lessee shall be at the liberty to vacate the said premises or part thereof at any time during the period of lease on giving so and so months notice. The lessee shall pay to the lessor in respect of the said premises a monthly rental of rupees so and so for the certain period of lease, and a monthly rental of so and so for the optional period of lease, payable within the 5th working day of each succeeding calendar month. The lessee has paid to the lessor a sum of rupees so and so only in respect of the said premises, else deposit of rent to be adjusted towards the rent for the last month of the tenancy. Further, you may also include this clause in the lease deed. The lessee shall be at the liberty to underlease, sublease to said premises or part thereof to any of its subsidiaries or to any other party. The lessee shall have the right to utilize the leased premises or part thereof for any of their various needs. The lessee shall grant all rights of way, water, air, light, and privy and other easement appertaining to the said premises, in witness whereof the parties hereto have set their hands hereto unto the full agreement of the terms and conditions set forth herein above the day and year herein above first mentioned, witness, lessee, and lessor. So this is all about the lease deed. Now we are going through the provisions or the clauses of partnership deed. The written agreement duly signed by the partners is known as a partnership deed. It is also known as an agreement or article of partnership. It is the document which mentions the rules and regulations, way of operation of management, and way of control of activities of the firm. It is also required at a time of the registration. It helps to minimize conflict and misunderstanding among the parties. My dear student, please keep in mind all these essential elements while drafting a partnership deed. The partnership must contain the name and address of the firm, name and address of the partner, name of the firm's business, duration of the partnership, amount of capital invested by the partners, interest on capital, division of profit, salary and commission, rights and duties of partners, admission and removal of partnership, valuation of capital and goodwill at a time of admission, death and retirement of partner, accounts and audits, resolution of partnership. So my dear student, please keep in mind all these essential elements while drafting a lease or a partnership deed. The format would be same as that of the lease deed. Mortgage deed. A mortgage is a transfer of an interest in specific immovable property for securing the payment of money or a present or a future debt. In a simple mortgage, both the ownership and the possession remain vested in the owner. This is the form of security only entitles the creditor in default of the repayment of debt to release it by eventual sale of mortgage property. In each case, the intention of the parties must be looked into if there is a debt or security of immovable property. Mortgage deed includes every instrument whereby for the purpose of securing money advanced or to be advanced by way of loan or an existing or future debt or the performance of an engagement. One person transfers or creates to or in favor of another a right over or in respect of a specified property. So these are the forms of mortgages provided under the Transfer of Property Act, and these are simple mortgage, usufructuary mortgage, mortgage by conditional sale, English mortgage, and equitable mortgage, and anomalous mortgage as well. So my dear students, while drafting the mortgage deed, please keep in mind the essentials of all these mortgages as well. So this is all about today's topic. Hope you have enjoyed and learned a lot out of this lecture. In case of any query, then you may write it to me at my email ID, that is rahularora.gn@jagannath.org. Before parting with today's topic, I just want to apprise you with my new topic, which I am going to take in my next lecture. And my next lecture would be on relinquishment deed and deed of gift, which I am going to discuss in my next lecture. Thank you very much. We'll meet you soon in my next lecture. Till then, stay home, stay safe, and stay healthy. Thank you very much again.